Okay.
So we do every Mother's Day as we set up for our Veterans Expo.
The House Oversight Committee will come to order. Clerk, please call the roll.
Mr. Chair.
Here.
Representatives Kelly.
Here.
O'Brien.
Here.
Leonard. Howrylak.
Here.
Townsend.
Here.
Robinson. Phelps. Mr. Chair, you have 5 members present. That is a quorum.
Okay, thank you. We are being televised by House TV. And is there a motion to adopt the minutes from the meeting held May 6th? So,
May 7th.
oh, I'm sorry. Can you change that to May 7th? Hearing no objection, May 7th minutes are approved. Is there a motion to approve April 29th minutes? So moved by Representative Kelly. Hearing no objections, those minutes are approved as well. Well, committee, and I know that we've got a couple other, oh, okay, Representative Robinson's here. Okay, good. So I know it's a little bit unusual time, but we've got, 2 national experts that have driven in or flown in, and so I wanted to make sure there was enough time for them to give the information that they're going to give to us. So I, just as an introduction, or kind of a setting up this situation, I was holding Winter Liberty discussions back in February on just some government surveillance. We were talking about GPS tracking and drones and some other things. And one of the reporter, and I was with Shelley Weisberg with the ACLU, and Representative Robinson was there, and somebody from Michigan Campaign for Liberty, and Detroit News reporter who's here, Lauren Abdel-Razak, was there, and she was, afterwards, she said, I was hoping to hear about Hailstorm. And so none of us really knew what Hailstorm was. We were talking about other devices. So I started, she and I guess the folks at Detroit News had been looking into it, so I started asking questions, and apparently the Oakland County Sheriff's Department does have this device, but I couldn't find out information. They weren't able to find out information about what its capabilities were. There's a few broad sentences, it sounded like, but I think it's certainly a surveillance device that really, it seems like we're not allowed to hear what it does, at least formally, and so I started trying to find out if we could actually get some additional information, kind of ran into some walls, and so I started asking around what can we find out from non-governmental agencies and individuals, and found the 2 gentlemen who will be testifying here, as they really are 2 of the national experts, and we're really, I'm very honored to have them here. I think it'll be very informative to the committee and to the public at large. I think we need to know how our government is surveilling us, particularly subsidiaries of the state, or I think we all have some responsibility to ensure that, that we understand it at least, and where appropriate that we try to contain it and put parameters around it. So I think one of the outcomes of this very well could be legislation, similar to what Lean has, where if unauthorized use, there's penalties, and there's a statute that says how data is handled. But also, I just think it's going to be important to hear what the capabilities are of the device. And although it's only in Oakland County right now, I would imagine we're seeing more and more municipalities and agencies using Homeland Security funds and grants to purchase these types of devices. So with that, I want to get right to the, yes, Representative Townsend.
Yes, Mr. Chairman, if I just may echo your sentiments about the importance of this issue, and thank you for your leadership in terms of bringing national voices to the table here. I would only add that I think we have a very compelling interest also in making sure that that private entities, corporations, and others are also on notice and being carefully they were being very careful and very prudent about who we're allowing to surveil us from the private sector as well, because I think this is a problem or a potential concern that exists on both sides of that divide. And in many cases, the private sector relies on the public sector for some basic infrastructure. And I think this is not just a public or governmental intrusion that we're concerned about. We're also concerned about people's rights to privacy from private sources as well. Thank you.
All right, thank you. And with that, we'll get right to it. Christopher Soghoian, with Principal Technologist and Senior Policy Analyst at the National American Civil Liberties Union, is here, and certainly welcome you, and are very interested to hear what you have to tell us about Hailstorm, Stingray, and please go ahead, feel free.
Chairman McMillan, members of the committee, thank you very much for inviting me here. My name is Christopher Soghoian. I'm not a lawyer. I'm a computer scientist. My job is to work with lawyers and to explain technology in English in terms that are easy to understand. I'm here as a subject matter expert. I've been studying the Stingray and similar technologies for 4 years now, and I have a law review article coming out in about 6 months focused on this technology. There's sort of two main points that I'm going to be trying to make today. The first is just to explain how this stuff works and where the technology came from. And then the second is to delve briefly into the issue of secrecy to help you understand that this is not, in fact, as big of a secret as you have been told. So the high-level picture of how this technology works. It seems very complicated, but it's actually relatively simple. The telephone companies like AT&T and Verizon operate large, expensive phone networks that allow us to make calls throughout the state, throughout the country, to our loved ones, to our colleagues, our friends. And the way they provide service to us is through cell towers. Cell towers have to be located. There are a lot of cell towers, and in fact, many more than there used to be to provide 3G and 4G data service. The more data that we need, the more phone towers that need to be placed around the state. And our phones basically connect to any tower that is nearby. The phones connect to the tower that is the closest or the one that has the strongest signal. And the Stingray or Hailstorm, these are name brand products sold by the Harris Corporation, and they are basically cell towers. They are cell towers in a briefcase or cell towers in a van or can be mounted on a drone. And they look like, from your phone's perspective, the tower of AT&T or the tower of Verizon. In fact, they masquerade as AT&T or Verizon. If your phone saw a tower that called itself the Oakland PD Tower, your phone would not connect to it. The way that they get your phone to talk to these Stingray devices is by actually impersonating the phone networks of AT&T, of Verizon, of Sprint, of T-Mobile. And so your phone is on your desk or in your pocket or by your bedside table at home, and a new tower shows up. It's an AT&T tower. It has a stronger signal than any other tower in the area. And so your phone says, great, I'm now using this tower. In the process of your phone connecting to and registering with this tower, the government, the police or FBI agent that is operating it learns a unique serial number associated with your phone, a social security number or some kind of unique identifier specifically associated with that device. And that allows them to know where the device is and to be able to see that the device that they saw last week is the same device that they're seeing today. This technology is an invasive technology. And what I mean by that is that these devices send signals through the walls of people's homes. They send signals through your pocketbook, through your pockets, into your car. Wherever your phone is, the signals have to reach them, which means that the police, these law enforcement agencies, are sending signals into protected spaces. Furthermore, as I noted before, these work through impersonation. Right? So the police, their equipment is masquerading as AT&T or Verizon equipment. Now, if the police were dressing up as an AT&T technician and knocking on 100 homes because they wanted to search the homes, I think people would be outraged. They would be outraged that the police were pretending to be the phone company, but that, in fact, is what the Stingray is doing. So the Stingray, for the first sort of 15, 20 years of this technology, they all had aquatic-themed names. So there was the Stingray, the triggerfish, the kingfish. At some point in the last few years, I guess the Harris Corporation ran out of aquatic-themed names, and so they've moved on to, I guess, weather-themed names. So the Hailstorm is the latest generation of this technology that is sold to law enforcement agencies. I also want to emphasize the overbroad nature of this technology. So it's not just that it goes through the walls of your house and sends signals into these private spaces. This technology is overbroad in its collection. So if you've played the game Marco Polo, either as an adult or when you were a child, that's really how this technology works. The Stingray tower sends out a signal, sends out a Marco signal, and every phone in the vicinity responds with its serial number. What that means then is that this is not just a technology that gets information about a particular target, the bad guy, the person who's being targeted with this technology. In fact, it allows them to collect information about hundreds or thousands of innocent people who are also in the vicinity where this technology is being used. So law enforcement will tell you, don't worry, we're only saving data about the targets of the investigation. That may be true or may be false depending on what their particular retention practices are. But they are definitely sending signals through the walls of innocent people's homes. These are people who've done nothing wrong. Their only crime is to live down the block from someone the police are investigating. And they will never learn at a later date that the police were sending signals into their house, into their car, into their pocket. So the technology really started, the technology is about 20 years old. It was originally used by the National Security Agency and the FBI. And over the last 20 years, largely through DHS grants, it's trickled down to local and state law enforcement agencies. So essentially, the police don't have to pay for this themselves. They get money from Washington, D.C. We know of about 15 states where this is being used at local and state levels, in addition to its use by federal law enforcement agencies. And although it's been used for at least a few years at the state level, it's really happened without any public debate. For the most part, to the extent that there has been any legislative oversight, it's happened at the city council level. So what will happen is that the local police will receive a grant, and they'll have to go to the city council for permission to spend the money. But typically, the police don't have to go to the state legislative body for permission to use this technology. And so, in many cases, this is something that has entered mainstream use by law enforcement agencies without any explicit legislative authority. There have not been laws passed permitting its use. They are using existing surveillance powers, although for a very, very different purpose. So this is a technology that's invasive. This is a technology that allows the police to collect information about innocent people. In the national security context, this is technology that can be used to collect information not just about the phone, not just collect location data, but is also used to wiretap calls. Because the Stingray or Hailstorm acts like the phone network, it receives the calls, it processes the calls. We don't know if local police use that functionality, but certainly the Harris products include intercept features, and other companies sell products like Harris. And that sort of brings me to the second main point that I wanted to make. You have undoubtedly been told by your own police agencies that this is a very sensitive technology, that any discussion of this technology could tip off bad guys, could allow bad guys to circumvent this surveillance technology. So the fact is that this is 20-year-old technology. It hasn't been used by local law enforcement agencies for 20 years, but this is 20-year-old technology, and the Harris Corporation is not the only company that makes equipment like this. There are plenty of other companies in the United States, in Israel, in Russia, in China, in India, who use this technology. It is sold on an open surveillance market. There are surveillance trade shows, bazaars in Dubai, in London, in Paris, where this technology is openly marketed. And many of the other companies that make equipment like this, their brochures are available online, their marketing materials are available online, not only detailing the features, but actually the underlying technology of how it works. Many of the companies that make this equipment have filed patents, and the patent filings reveal in great detail the implementation details of how the technology works. And on top of that, this is technology that graduate students can now build. There are master's theses from German students and PhD dissertations that have been written by students building their own Stingrays, building their own Hailstorms. These students and researchers have given demonstrations at security conferences. The software to create these things is available online. And so what this means is that this really isn't as secretive as you've been told. You can find information about this stuff online, both how it works, how to defeat it, how to even build your own. You can buy one of these surveillance devices from a company like Harris, not the Harris device, but you can buy the competitors' products for $5,000 or $10,000 online from Chinese resellers. And at this point, every tin pot authoritarian government that wants it has it. This is in widespread use around the world. This technology is not a secret. anymore. And as much as the law enforcement community would like it to be a secret, that horse left the barn a long time ago. At this point, the only real impact of the secrecy is to keep bodies like yours in the dark, and to keep judges in the dark too. But I've spent 4 years researching this technology. I'm happy to answer any questions that you have to help you understand how this works. But there is a lot of information about this stuff already out there right now, and so you shouldn't believe everything you're told about the secrecy of this technology. Thank you very much.
Thank you, Christopher. So is this something that other legislative bodies have been dealing with and holding hearings on?
So Michigan is the first state that I know of where there's been a hearing focused solely on stingrays and hailstorm and similar technologies. I think in Minnesota they had a hearing a few months back generally focused on cell phone tracking where the stingray stuff came up, but this is the first state where there has been a specific hearing on this. I know that in Utah and Indiana, those two states recently passed legislation requiring a warrant for cell phone searches that also encompasses the stingray, although I don't think they held a specific hearing to understand the technology first. I think they were included as part of a broader package on cell phone privacy.
Okay, and you mentioned stingray a lot, but again, just to reiterate, hailstorm is the next generation of stingray?
The hailstorm is the latest and greatest generation available to law enforcement. It is my belief and understanding, based on the research I've done, that the local law enforcement agencies are a couple generations behind what the feds are using, and particularly what the intelligence community is using. So you have really cutting-edge and very expensive Harris devices that are mounted on drones in Iraq, Afghanistan, and war zones, and then you have older technology being sold to local law enforcement agencies without as many bells and whistles. The stingray is something we know an awful lot about because it's maybe 6, 7 years old. At least it's been used by local police since I think 2007, 2008 is when it went onto the market. The hailstorm we first learned about last year. We still don't know what the unique features of the hailstorm are. Oakland is one of the few places in the country where documents even acknowledging its purchase have been made public, and so we're still not sure of what the special sauce in the hailstorm is. But there are enough serious privacy concerns with the stingray, let alone whatever the new features that are in the hailstorm, that I think this committee can take a serious look at this technology.
And then when we're talking about potentially, not only is the mobile tower that the hailstorm mimics or has a stronger signal, but they also can jam other towers. Is that correct? And would there be potentially some safety issues, and just can you talk a little bit about that?
Sure. I hope I don't lose anyone because this is going to veer even more into the tech space, but there are various generations of cell phone technology. So the latest and greatest generation is called 4G or LTE. Your phone, if you have a new iPhone or Android phone, you are almost certainly using 4th generation technology. The previous one is called 3rd generation, 3G, and then the older generation, the oldest generation, is called 2G. And if you are driving in a rural area, your phone will typically be using 2G. The phone companies typically have the latest generation technology in urban centers, and then they have the older technology in rural areas. And the stingray and hailstorm technology works at the 2G level. And so if you have a brand new $600 iPhone and you're using a 4th generation network, they have a problem. How do they trick your phone into using their network when your phone is only connecting to 4G towers? Well, your $600 phone will still connect to a 2nd generation tower if you're out in a rural area because you need to be able to make calls. And so what they do, the law enforcement agencies that use this technology will jam 3G and 4G. They'll jam the nearby phone networks for the latest and greatest generation of technology. And then there's a 2G tower, the stingray, that shows up, and your phone connects to that because it wants to get online. And so what that means then is that the successful use of this technology in many cases requires jamming of phone networks. Regardless of your views on the privacy aspects of this technology, I mean, I personally feel like this is a very invasive technology, but regardless of your views there, I think we should all be troubled by the prospect of law enforcement agencies going around jamming phone networks. These are devices that we use to communicate with our loved ones, with our colleagues, with our families in emergencies. It is my understanding that the Stingray and Harris product line will always allow 911 calls to go through. So that's good, but the police don't know the telephone number of your doctor. They don't know the number of your priest or your rabbi, of your wife or husband. And so if the technology is jamming calls, there may be instances where you're not able to make a call in an emergency when you most need to, simply because 2 blocks away the police are driving through your subdivision using one of these devices. And so I think the jamming features of this really need to be looked at. I think many people understand that phones play a vital role in our society today, a public safety role, and any potential disruption to the phone network is something that should be really looked at before we allow these agencies to run around doing this.
And then are we only talking about phones, or now iPads, can have communication as well? I mean, does this get into computers as well?
Sure. So there are mobile devices like tablets that can get data connectivity through the phone network. So you can pay, AT&T $50 a month for a data connection for your tablet. You can also buy a little thumb drive that provides wireless connectivity to your laptop. I see the reporter behind me, she has one here. Those devices use the phone network, and so Stingrays and Hailstorms can also track those devices too. In many cases, the Stingray may be the method of choice for locating data using tablet users for technical reasons that will probably bore you. When a Stingray or similar device is used, the police learn about every device in the neighborhood, every device in the vicinity, and that can be phones, that can be tablets, that can be laptops. They may be focused just on the bad guy, but until they know who the bad guy is, they're going to be probing a lot of other innocent people's computers, and even if they know who the bad guy is, there's the nature of this technology is such that it over-collects information. It over-collects information about innocent people's devices.
Okay. And so if there's the bad guy's over here, they think he is, but he's surrounded, there's 10 other people in the area. This device would potentially collect, it may not save, or it might, we're not exactly sure, but it would potentially collect data on the other 10 innocent bystanders.
So let me explain the sort of major scenarios where this technology is used, and then that will help, I think, to answer your question. So there are 2 really big scenarios and a few lesser ones. The first is where they have a general idea of the vicinity that the person's in. Maybe they know, he's in the northeast part of the city, but they don't know exactly where. And for technical reasons, the phone company's not able to give them any finer grained data. The phone companies can in many cases provide high accuracy location data with surveillance features built into phones, but the GPS chip in your phone won't work indoors, for example, or there are other scenarios where your phone may not be able to provide high accuracy location data. And in those cases, if they know that you're in the northeastern part of the city, the police will drive through neighborhood by neighborhood, sending out these signals, sending out these Marco signals, and waiting for the polo responses of every phone in the neighborhood until they get the polo from the particular phone they're looking for, the tablet or the laptop they're looking for. That's the first scenario. The second scenario that frequently comes up is where you have a target who is switching phones with frequency. So you can buy a prepaid cell phone at CVS for $20 if the target of the investigation is throwing away their phone every week. The police know where the person lives, they know where they work, they know where the person's girlfriend's house is, but they don't know which particular phone they're using in that moment. Then they can show up outside that person's house and get a list of all the phones that are in that neighborhood, or at least that are in the vicinity of that house. If the person's living in an apartment building, they might get the 50 other phones that are in that high-rise apartment. It really depends on whether they're just using it outside one house or whether they're driving through a neighborhood. But when it's being used, typically it will allow them to collect data about other devices that are nearby. And the only real privacy protection we have is whether or not they're keeping that data. I personally feel like the invasion to privacy happens the moment they send the signals through the wall of my house. The fact that they later delete the information they obtained isn't really of much comfort to me.
Okay. And I want to get through a couple questions, but I want to circle back to potential oversight, or what oversight is. I've been told to just trust us, but I think NSA's director James Clapper said the same thing, and I think we understood that the paradigm is shifting. I think that law enforcement needs to go out of their way to assure the public that they're not doing anything wrong, and I really hope that paradigm is starting to shift. I hope it continues to, because I think that when he lied to Congress, I think it kind of really was revealing to folks. So, Representative Robinson.
Good morning, and thank you for coming. Yeah, your information has been very useful for me. The question I want to ask you: do landlines, are they affected?
No, Representative, they're not. This is a technology that focuses solely on cellular technology, so cell phones, laptops, tablets, anything using wireless networks.
So we should keep our landlines. No. But anyhow, does it also apply to voice over internet?
If the voice over internet is working over the phone network, then yes. If you're using the Wi-Fi connection at Starbucks, then no.
Okay. Now, it's intriguing to me. Are these devices available to private citizens, corporations?
That's an interesting question, and I guess that gets into the area where I think Representative Townsend brought that up at the beginning of the session. The federal law says that this is something that cannot be used by private parties, but of course criminals are willing to break the law. The fact is that in other countries this has been used and abused by criminals. In India, for example, you have the most information we know about where private parties, the press, the paparazzi have used these devices to spy on the calls of politicians, of film stars, of CEOs of companies. The fact is that, for $5,000 or $10,000, you can go online, you can buy a device like this, and you can park outside someone's house and listen to calls that are taking place inside their house. I think there's a separate and significant and important issue that we should be talking about as a society about whether we should have safe and secure phone networks. Right now, our phone calls aren't really secure. The only thing keeping you safe is probably the fact that most people are not listening. In the mid-90s, the older generation of phone networks we had were so vulnerable that with a radio scanner that you could buy at Radio Shack, you could tune to the right portion of the dial and listen to people's phone calls. In fact, in I think 1996, Newt Gingrich's phone calls were intercepted by a couple in Florida who were just tuning in on a radio scanner. It's now a little bit more expensive to intercept calls, but it's not that expensive for people who really want to do it. And you could easily envision private investigators or corporations wishing to engage in espionage or in corporate espionage. I really do think we should be having a discussion at some point about the security of our phone network and whether you should be able to have a private call with your doctor that really cannot be tapped. But because this technology is being used by law enforcement, because it's being used by government agencies, there has been a reluctance on the part of government agencies to have that discussion about protections from other parties that are intercepting calls. But yes, I think there is the risk of private parties using this technology.
I just have one final question. Who in the what agency in the federal government is distributing these devices, and what motivated them to do that?
So the answer to that question is slightly complicated, but the quick version is that the Harris Corporation, which makes the Stingray and Hailstorm technology, they have to seek permission from the Federal Communications Commission, the agency that has oversight of the phone networks. So they go to the FCC every year or two when they have a new surveillance device they want to sell, and they get permission from the FCC to sell the technology. As part of its process of providing the licensing to Harris, the FCC has asked the FBI to be the coordinating agency nationally. And so the FBI is supposed to be keeping watch over the use of this technology by law enforcement agencies. Doesn't really look like that's happening. We learned, for example, just a few months back that the police in Tallahassee, Florida have gotten some Stingrays and used them 200 times without ever going to a judge or getting a warrant. They interpreted the non-disclosure agreement they signed with the Harris Corporation in such a way that prevented them from even telling judges what they were planning on doing. I think there are serious problems with that, and I think that shows the toxic effects of the secrecy around this technology. But in essence, the FCC and the FBI are the two big agencies that are pulling the strings here. Separately, you have DHS giving out the money to pay for this stuff. And so most law enforcement agencies who've acquired this technology are not using their own money. They've received free money from Washington, D.C. You know, you get to buy the gear, you get to send a couple of your officers to a training course. And so that's come through DHS grants given out largely through FEMA. DOJ, I mean, the FBI is a component agency within DOJ. Some law enforcement agencies have referenced signing non-disclosure agreements with DOJ as well. We don't really know what's happening there, but it seems like the FBI is the most active player in this. We have Open Records Act requests we've filed around the country, and the FBI appears to be playing some role in coordinating the responses, because the arguments we're seeing about the Homeland Security Act and other things have come out of nowhere in all the states at the same time, and the FBI are now filing affidavits in some cases. So I suspect that they are the biggest player here.
Representative Townsend?
Thank you, Mr. Chairman, and thank you for coming today to educate us about this issue. And I certainly share the concerns that are being expressed about the serious nature of potential abuse and maybe some real abuse that's already happening. I have a couple of questions. The first one is, you mentioned, you described how this works and the fact that, you know, when there's sort of competing towers, you're driving down the road and you come upon a tower, if that tower has a strong signal, it will attract your phone, and your phone will start utilizing this, you know, the capacity of that tower. How come then every time I seem to be driving around and I can see a tower, my phone still doesn't work?
So that's probably a question you should.
I'm just kidding.
You should bring to the phone companies. What I will tell you is just because you see a tower nearby,
Yeah.
that may not be a tower providing service to your phone.
Okay.
So you may be seeing a Verizon tower when you have an AT&T phone.
And that was my question. There seemed, because it sounded like from what you said that sort of all towers service all phones, and that is not the case.
No, sir. So
Okay.
the phone networks provide service to their own customers only, but typically, I have to generalize somewhat, but in many cases, the phone companies don't actually own the towers. So AT&T doesn't own the tower. There are companies that build and maintain the towers.
And they lease the...
And then AT&T and Verizon will rent space on that tower, and you may have multiple phone companies that are present on a single tower. They'll have their own equipment. They have their own little antennas and stuff, but you will typically have multiple companies hanging out on a tower, but that doesn't mean you'll have 4 or 5 companies present. And so, you know, you may find that you have service and you're an AT&T customer and your wife, who's a Verizon customer, doesn't have service, or vice versa.
I asked that question not to get into that subject too deeply, but really, so the way this works is that your phone is kind of like this innocent that goes along, and the tower, depending on who owns it or the part of the tower that one company might own or lease, sees your phone, and if it's someone they have a contract with, then they will allow that phone to make use of its services.
So your phone is duped.
Right.
Your
Okay,
phone
so
will connect to any tower that calls itself an AT&T tower,
Right.
if you are an AT&T subscriber. And your phone has no way of knowing if it really is an AT&T tower that it's talking to, or if it's an FBI tower pretending to be an AT&T
Yeah.
tower, or if it's a private investigator with an AT&T masqueraded device as well.
Right, so it can be anybody. So I get that. So as a follow-up to that, then how big is the Harris Corporation's got various products, and there's other folks out there. Can you generalize about what the sort of the scope of coverage is for one of these portable towers that poses as a...
So there are a range of products that are sold. The devices range in size as well. There are small ones that can be held by someone's hand. You can walk around with one of these things. There are devices that can be worn on your person, can be strapped to your chest. I've seen photos of these that have been taken at surveillance trade shows. They are advertised for use, for example, at protests. So if the Egyptian government wants to know who's protesting, you know, a democratic protest, a police officer, an undercover police officer, can walk through the protest and then collect the device information about everyone who's attending the protest. And this is not a crazy idea. Just a few years ago, the police in Miami purchased one of these devices because they said they needed to use it to monitor illegal activities at a free trade, anti-free trade agreement protest that took place in Miami I think 2007. So there are small ones, there are larger ones that will fit in a van or an SUV.
But
They
their
can be-
scope depend, I mean, the coverage area can vary a tremendous amount, then I guess. is what
Coverage
you're saying.
area depends on the antenna
Okay.
and the amount of power that they wish to provide to the antenna. Furthermore, there are some antennas that are directional, as in they can point the antenna at a specific house and just send the signals there. And then there are other antennas they have that will send the signals in all directions. So the Wi-Fi router you have in your living room sends signals in all directions, not just in one direction.
So, and I have one follow-up, if I may, Mr. Chairman. So what you're telling us there is that there is technology or categories of technology that could be I mean, we could narrow the public uses of this technology to technologies that can target specific phone numbers or such. Now, it wouldn't, obviously, the police wouldn't be able to scan around like you were suggesting, that scenario where they go through a neighborhood looking for one phone number and they finally found it after they've gone through 1,000 others.
So
right?
if they were solely using it in the context of learning which device a particular person is using, where they know where that person is, they know where that person works, and they're just sitting outside the guy's house, they could certainly use a particular kind of antenna to focus the signals just into the living room. Now, that they are going to be picking up signals of other people in the house. If the person's living in an apartment building, they may be getting signals of people in neighboring apartments.
Right. But it could be geared in such that it only picks up one phone number if it were. I mean, you say someone got a warrant and said, we're going to look up, 313 ... whatever the number is. The warrants could say you're only allowed, your technology you're only allowed to use it to find that number, and you're only allowed to use it to monitor that number as opposed to others and then finding that number.
My concern here would simply be that law enforcement might interpret that to mean they could only save the information they collect about that particular
Right.
phone number. I mean, I think that many police agencies who are using this don't really understand fully how it works. I think they think of this as a magic box, that they turn it on, they
Right.
punch in a number, and suddenly it tells them where the bad guy is. And I don't think many of them realize the impact it has on innocent people. I think many of the judges who've signed these orders, to the extent they even know that they're being asked to approve the use of this technology, I don't think they understand.
They don't fully get it. I want to move to one other question, if I could, and that is your comments about jamming and how jamming works. I'm a little confused about what you described, and probably it's because I just don't understand the technology. You said that there is a risk, and the chairman mentioned this, and it does sound like a real concern, if one of these fake towers comes along and jams the surrounding towers and prevents those from working. But it must, I mean, if this is a tower, this fake tower comes in and jams the others, it must still allow calls to go through. Otherwise, I mean, the criminal they're targeting you wouldn't gather much information if no calls were going through.
So the calls would then go through the Stingray or the Hailstorm device itself.
Right.
So on the jamming point, I should also note, one additional use of this technology, and one that I suspect that law enforcement and federal agencies consider to be even more sensitive than the surveillance use, is the jamming feature can be used in IED scenarios. So if you have someone who has a bomb who's going to try and explode the bomb remotely, a Stingray can block all calls from taking place, or can block all calls except a few numbers. If you have a hostage situation and you want the bad guys, who are holding the hostages not to be able to call any of their colleagues, this technology can allow you to stop all outgoing calls except to the negotiator. The Secret Service uses this technology, to keep the president safe. And the fact is, it's really difficult to have a super sensitive intelligence technology used, in critical national security context, in war zones, by the NSA, by the Secret Service, and then also have it being used in local small towns. I mean, this is what happens when, federal money pays for surveillance technology. This stuff trickles down. Yes, this is an important technology. I'm sure it's very useful in Iraq and Afghanistan, but now that it's being used on Main Street, I really think the rules have to be different. And this technology may be appropriate in Afghanistan and may not be appropriate here in Michigan.
Well, I really appreciate it, and appreciate your indulgence. I think I would just argue that the same sort of concerns about military-style technology or whatever would also apply to a lot of categories of weapons that we're seeing on our streets. Thank you very much.
All right, Representative O'Brien.
Thank you. That was actually a good segue into my question. There's been a lot of conversations about how should technology be used. In the United States, do you ever feel there is a time where this technology, as it exists today, should be used and be allowed to be used?
So I think it would be useful to have a debate about that. I think it's the role of legislative bodies like yours to find that balance and to say these are the kinds of cases where it's appropriate to be used. You know, we have a ticking bomb, okay, we use this technology, but what's happened is that this technology has made its way into local police departments through grants from Washington, D.C., without your committee or other committees in various other states ever having the opportunity to weigh in and to set the rules of the road. There is no state in this country where there is explicit authorization, there's specific legislation authorizing the use of this technology, with the exception of Utah and Indiana that just passed their laws in the last month. I think that we need to have a debate about when it's appropriate to use this technology, but I personally feel like a technology that's collecting information about hundreds or thousands of innocent people goes beyond the limits of what is reasonable, with you know, a few exceptions. But this is not a debate that has taken place. Law enforcement agencies have kept the public in the dark, and they've kept legislative bodies in the dark, and I think to a certain extent they've kept the courts in the dark as well. And now, you know, their intentions are pure, I think. They don't want bad guys to learn the technologies they have. But because they are so driven to keep information about this technology out of the public eye, they've also kept legislative bodies like yours in the dark too, and I think that's not appropriate. I think, you know, you represent, you know, your voters, and you should be told what's happening. You should be told how this technology works. You should be told how it's being used, and you should be told the kinds of crimes it's being used to investigate. But, you know, I suspect there are probably not a lot of terrorists in this state, and you give police this technology, and it's really useful, right? It means they don't even have to go to AT&T and ask for help. They can just get this information themselves. And you give them the gear. It's really cool, right? You feel like a secret agent when you're using this, and they're going to start using it. And you know, they probably don't have very tight controls over how it's used right now. Certainly in other states where we're learning information, you know, what we're learning suggests that this is being used for fairly mundane, run-of-the-mill crimes. And where I think the intrusion into the privacy of innocent people really outweighs whatever potential advantage there is for law enforcement.
Are you aware if Congress or other federal officials are debating this in Washington, D.C.?
There have been no public hearings in Congress. There was a question by, I think, Gerald Nadler, the representative from New York, about a year and a half ago after one of the Wall Street Journal stories about this technology. He asked the FBI about this, and they sent him a one-paragraph response basically saying, this is really sensitive and really important, and that was that. It's sad that there haven't been any investigations at the federal level, but I'm delighted to see that Michigan is you know, pointing everyone else in the right direction.
Well, thank you for coming here today. I think this is a conversation to be had.
Thank you, ma'am.
I do want to get to the judge and then also talk after that about oversight suggestions from both of you, but Representative Kelly.
Thank you, Mr. Chair. You mentioned earlier that we were one of the few states that are taking this up, but yet you mentioned Indiana and Utah. Do you know specifically what they have done?
So I know the most about Utah's law. Utah passed a fairly broad package of cell phone privacy legislation. So they require a warrant signed by a judge, probable cause-based warrant, for any search of a phone, whether that is the police stopping you at a traffic stop and taking your phone and physically examining it, or remotely locating the device using a Stingray, or asking the phone company to find your phone. However the police search or surveil your phone, in Utah now a warrant is required, with a few exceptions for public safety emergencies. So if there's a missing child, or your phone's been stolen and you consent to it being located, or, you know, there's a ticking bomb, then they don't need a warrant. But Utah did this in the context of a broader privacy push, and so I know they were interested in the Stingray issue. There had been newspaper articles about this technology that I think pushed them in that direction, but it's my understanding that there was not a specific Stingray Hailstorm hearing in Utah. This state is special, at least for now.
All right. What I'm going to do is ask the former judge to come up, and then if we have time, we got to leave about 5 till 1. I'd like for both of you to come up and talk a little bit more about policy and what we probably ought to look at in legislation. But for now, thank you very much, Christopher. It's been extremely enlightening. And
thank you.
Thank you. So now I'd like to bring up Brian Owsley. Brian, I'll let you go ahead and he could, Christopher, if you want to go ahead and sit down, and then I'll bring both of you up at the same time if we have enough time. Brian, I'll let you introduce yourself. You were a federal magistrate, and I got notice of some of the, you've dealt with this issue. You're one of the few judges or former judges in the nation that has actually wrestled with this issue, it appeared to me anyway, from what I was able to gather. And so I appreciate you coming here, and please inform us of what you'd like to say.
All right, great. Thank you. My name is Brian Owsley, and as Representative McMillan said, I am a former United States magistrate judge. I served down in Corpus Christi, Texas, on the Southern District of Texas for 8 years. I am currently a visiting assistant professor at the Texas Tech University School of Law, and starting in the fall, I will be teaching at Indiana Tech Law School in Fort Wayne, Indiana. And I want to thank Representative McMillan for inviting me here today. I want to thank the committee for having Chris and I talk about this issue that we are both very engaged in and very concerned about. And it's heartening to see that states are now starting to take this serious as well. So what I want to speak about generally is sort of my experience in terms of Stingray devices. And then we can talk about maybe some policy issues after that. So the first time I experienced or came across a Stingray device was in April of 2011. And what happens is I get an application. It is essentially referred to as a pen register application. For those of you who don't know, a pen register is essentially in the federal code, a means by which law enforcement would come in and they would seek for a specific known telephone number all the outgoing calls from a certain time period. It's a relatively routine application. It can be done on landlines as well as cell phones, and there's a sort of corresponding device called the trap and trace, where you get all the incoming phone numbers to a specific known telephone number. And that's essentially, a trap and trace would be kind of like when we had landlines, the caller ID box, or when you know, your cell phone tells you who's coming in. That's a trap and trace device. And those requests are very routine for federal magistrate judges to handle. They are essentially very low standard. So if we think of the Fourth Amendment and the probable cause standard and the requirements that would be entailed there, the standard for a pen register is considerably lower. It is basically an assistant United States attorney has to file an application certifying that the information sought is relevant to an ongoing criminal investigation. And I glibly describe it as, if the agent comes in with a pen register application and has a pulse, and the magistrate judge has a pulse, there's going to be a pen register signed that day, because the standard is essentially so low. So when I first saw this Stingray device application, it was couched in the terms of a pen register application. And so I started asking some questions. I asked colleagues on the bench who also struggle with these surveillance issues, and I asked the assistant United States attorney who was filing the application. And the background was essentially there were some inmates at a federal prison in Three Rivers, Texas, who were purportedly using a cell phone. And they were engaged in some kind of criminal activity, some kind of improper activity, because it was not proper for them to have that cell phone to begin with. So the government wanted to ascertain that telephone number. Now, to me, that makes sense. I can understand why law enforcement would want to do that. We can have a discussion about, you know, maybe the parameters and the use of Stingray, but in my mind, that seems like something of a reasonable use of a Stingray device to ascertain that number and then, you know, launch an investigation from there. But I was still troubled by the application, and I asked some questions. And so what I was told was by the assistant United States attorney was essentially, well, I'll prepare a memo. I'll get you a memo on why the statute that we're applying for this is the appropriate statute, and you know, the basis by which we're seeking this authority. So I waited, and some time goes by, and every once in a while I'd see this assistant United States attorney, and I'd ask where the memo was, and was told that the memo was forthcoming. Eventually, I was told by the assistant United States attorney that, oh, well, a couple days after we filed the application, prison officials found the cell phone. So I don't, you know, I said, well, good, that solves the problem, because then you don't need the application because you have the phone and you can go from there. Essentially, I denied the application as moot. I didn't analyze it. I didn't go into determining whether or not the statute was the proper basis for it. It was, for someone who had a fairly busy docket, an easy way out to solve the problem. And so that was that in that case. Then, about a year later, I get another application. And this one was from a DEA agent in a narcotics trafficking case. So again, pen register application, and the government doesn't have the cell phone number. Essentially, as Mr. Soghoian was referencing, this was a type where they knew who they were investigating, but they did not know what phone he was using. So they wanted to ascertain his phone, and in discussions with the government and the agent, what I understood was they were going to take the device, they were going to set up surveillance outside the subjects or the investigation's residence, and gather some data there. Then they would follow him when he went to a club or a restaurant or a bar or the gym, wherever he was going. They would follow him for a certain time period and gather intelligence from a multiple number of locations. And based on that, they would basically have a set of telephone numbers for each location, and the hope would be to find essentially one cell phone number, or at least winnow it down to a couple cell phone numbers, and they would have a sense of what number or numbers he was using. So that was that application. Again, I asked about the basis, the legal basis by which the government was seeking authority for this. Again, I was promised a legal memorandum from this. And in fairness, in defense of the local assistant United States attorneys that I was interacting with, this is something that they are getting from Maine Justice. So this is guidance that they get from Maine Justice. There is a document known as the Electronic Surveillance Manual, which is, at least portions of it are available on the internet. And there is an application that shows what the AUSA is supposed to do when they file a pen register application. And similarly, there is a model form and a proposed order for what they're supposed to do when filing for a Stingray. Now, at that time, it was known as a triggerfish, which, as Mr. Soghoian referenced, was one of the earlier iterations in the nautical series that Harris was putting out. But in other words, there was a development of a pen register application-like form for cell site simulators for Stingrays. And so any kind of memorandum similarly would have to come from Maine Justice, presumably, because I don't think, one, that the assistant United States attorneys understand the legal implications that well, and that guidance is typically from Maine Justice. In fact, when I talk to assistant United States attorneys about electronic surveillance issues, typically you get sort of a blank stare in response if you're asking them how it works or the ramifications of certain things. In the case of Stingrays, when I talk to the agent the DEA agent, it was clear that he had used it before. He got very animated. He talked about how he was going to use the technology. So it was clear that he understood it in a way that the Assistant United States Attorney did not. So I kept waiting for the memorandum, and ultimately it never came. So I issued a written opinion and captioned, "In the application of the United States for an order authorizing the installation and use of a pen register and trap and trace device." So you can see even in the caption that they submit, they're sending it to the judge, to me, as a pen register and a trap and trace device. That's case number 890, Federal Supplement 2nd, 747, Southern District of Texas, 2012. So I denied it for a couple of reasons. First, I concluded that the pen register application was not the appropriate basis for granting any such application. As I did research and analyzed it, I concluded that a pen register requires a known number. Here, what they're using is a device trying to ascertain an unknown number. And so that was troubling in terms of the use of the pen register application. Essentially also concluded that the standard, as I indicated, for a pen register was so low that, and this device was so invasive that it would not be appropriate to grant it under that low standard. I concluded that the appropriate standard would be the Fourth Amendment and a probable cause standard. In the decision, I touched on my concern about the innocent bystanders, the third parties whose data and information would be swept up. I concluded that they had a reasonable expectation of privacy in their use of their cell phone, and based on that, I was concerned that the government had no plan or thought process about what they were going to do with the third-party information that was inadvertently swept up. I wanted them to, and explain to them that if they were to get the authorization, they would have to notify these third parties that their information had been swept up and destroy the records of the information that was not relevant to the criminal investigation. So in other words, they'd have to destroy the information related to the third-party individuals. Now, I want to touch on the pen register application approach, which I find troubling, because I've looked at a number of pen registers. To my knowledge, my order is only the second order that addresses a cell site simulator, Stingray type device. There is a decision from a California federal magistrate judge in, I think, 1995 that deals with an older iteration. It refers to it as a digital analyzer. It's a sort of a predecessor, as I understand it, to the technology that law enforcement are using today. And significantly, it was before the Patriot Act was amended or enacted in 2001. And so I think that changed some of the landscape.
So Brian, I think what you're saying is that you're concerned, or you believe that law enforcement might be asking judges to use one thing, something that's very low standard, very easy to get, but they're actually potentially using it for something else. Is that
precisely? Okay. So magistrate judges are very hardworking. They're a very intelligent group, but they may not be the most tech-savvy individuals that we come across. There are exceptions, but I can envision scenarios where a magistrate judge gets something that looks is labeled as a pen register, kind of looks like a pen register application, and signs it under the belief that is a pen register application, and is essentially ordering or authorizing the use of a Stingray device. And so I'm troubled by that possibility. Unfortunately, it's hard to know because these applications are typically sealed. and they tend to remain sealed. So for someone like me, who now from the academic side, it's hard to get information to conclusively analyze this issue. But I think that in talking to magistrate judges around the country, many of them aren't aware of this technology, and to the extent that they are, they're struggling with it like I was. So I think that there needs to be an approach where it's clear what the government, whether it's a state law enforcement agency or a federal law enforcement agency, is asking for. It needs to be clear as to that it is actually a Stingray device that the government is seeking to use, and not a pen register to get some outgoing telephone numbers. So with that, I'll conclude my remarks, and if there are any questions, I'd be happy.
Representative Townsend?
Thank you, Mr. Chairman, and thank you, I guess we'll call you Professor Owsley or Judge Owsley. My first question is, you've spoken a lot about the pen register process, I guess. What is this federal statute that authorizes that?
That is 18 U.S.C. It starts at 3121, but you'd probably want to hone in on, I think, 3123.
Okay. Is there a state, I mean, whether that, and I don't expect you to be an expert on laws in the state of Michigan, but are there state-level laws that act in the same way, that offer the same sort of low level of clearance for somebody to get authorization?
I'm not an expert on how these things are being handled at state level. I know that state judges authorize those types of electronic surveillances. The statutory schemes vary from state to state. So, but in my experience, states typically seem to be more towards the Fourth Amendment probable cause standard for a lot of electronic surveillance requests that the federal government may seek authorization for less than a probable cause standard.
So you're saying that generally speaking, states have a higher standard in terms of what they require in order for a law enforcement agency to gain a warrant for that kind of surveillance?
That's been my experience,
Okay.
to the extent that I've looked at it.
Okay, and then my final question for now, at least, is the briefing materials we received before this hearing made mention of a Supreme Court case called, and I don't know how to pronounce it, it's called the Kilo case from 2001.
Right.
How do you say that, first of all? Do you know?
I say Kylo.
Okay, Kilo sounds good to me.
I could be pronouncing it wrong. I just learned I was pronouncing some other Supreme Court case wrong for years. So,
well, nobody will hold that against you, I don't think. That case, as I understand it, deals with it was from 2001, and it seemed to reference, or it seemed to mirror somewhat where you came down on this in terms of finding that a surveillance directed, and this involved a heat, detecting heat coming out of a home, right? Thermal surveillance that was done, and the court in that case found that, or held that that wasn't a search that fell under the Fourth Amendment and would require probable cause. But that was of a home. What we're talking about is obviously a different situation. Now, a cell phone might very well be within a home, but we're talking about surveillance of people who are can be anywhere. So I guess just, from your legal experience, how would you relate the kinds of issues we've been dealing with here today with the precedent that we have before us in the Kilo case?
yeah. As you noticed, Kilo was a situation where a guy was growing marijuana hydroponically, and so that creates a lot of heat, and so the government used this technology to basically go through the walls or the exterior of the house to ascertain the heat level, and the court essentially said that needed a search warrant. That was a Scalia decision, and Justice Scalia has essentially created a number of decisions where he is refocusing the Fourth Amendment to a trespassatory approach, and so he is safeguarding the House. And so someone like Justice Scalia might say that a phone is different than the house because the house is mentioned specifically in the Fourth Amendment and historically has been safeguarded in the same way. There is also a decision entitled Smith versus Maryland, which deals with pen registers and talks about that there is no Fourth Amendment protection on the outgoing numbers that a pen register would provide. In other words, and that was, as I referred to the Smith case, my grandmother's pen register. It was long ago. It was before cell phones were even I don't want to say thought of, but being utilized. It was in the early 70s. So the technology is very different. But what I will say about Smith versus Maryland, while the federal government has a lesser standard for protection of pen registers and the notion that there is no reasonable expectation of privacy, I can't speak for Michigan, but I do know that a number of states, Supreme Courts, have specifically rejected the application of Smith versus Maryland in their own state. So in other words, they conclude that people do have a reasonable expectation of privacy in their outgoing numbers and information related to their telephones, including their cell phones. So this is something that states are struggling with, and they're not necessarily agreeing with the federal approach.
Thank you very much. I appreciate your testimony.
You know, and we'll get into some oversight and maybe suggested statutory items, but from what you mentioned, one area might be of consideration would be that if this device is going to be used, that law enforcement be required to mail anybody who, you know, had an innocent party who had their data collected and let them know that we collected your data, we're sorry, or you know, it was in part of an investigation or whatever, and this is what we did with your data to make sure that it's destroyed or whatever. I mean, that seems like one area that you've kind of thought about and potentially used, I think, in other data gathering.
Exactly, and I think that's critical in this approach, and it does a number of things. So one, it does actually give notice to the innocent third party so that they're aware that their information was compromised on some level. It gives them an assurance. I don't know how great of an assurance it is, but it gives them some assurance that purportedly their information was destroyed. And so that means, I think, two things to me. Any physical hard copies would be destroyed, shredded, you know, or whatever, and any electronic copies would be deleted or destroyed in that way, and scrubbed. So you have that. But you can envision if your constituents come and say, look, I got this letter, I'm troubled by it, what does it mean? And so you would get some insights and some feedback, I think, from the electorate as to how they're perceiving or feeling about this. And then if someone, either depending on where they live or who they associate with or whatever, it starts to get multiple letters, then you can, someone might get one letter and be somewhat troubled by it, or, mention it to friends and neighbors, or even call up their elected officials. But if someone's getting 3 or 5 letters, then you start to sort of say, what's going on here? And that might be revealing in and of itself.
Right.
So.
Representative Phillips?
Thank you, Mr. Chair. I just wanted to clarify, because I'm not sure if it's been made, as clear as I wanted to hear it right now. But when you say pen registry, when they, I guess, would apply for, the judge's approval of a pen registry, if they're using the type of devices that are starting to come into local law enforcement, what other types of information could be collected with those devices besides just the pen registry? What other types of, I guess, info that is being transmitted from the phone could they get, and data?
Well, let me make sure I understand. So a pen register, and Chris talked about this in terms of the Stingray essentially removes the phone company because you're mimicking their tower and you don't have to get any information from them. In a pen register, you go to the phone company and you say, I want a list of all the, from this date to this date, all the numbers that were called out. In terms of other technology, there are, for example, in the federal code, 18 U.S.C. 2703, you can get all kinds of subscriber information. So if you come in with a specific telephone number, you can get the information, the name, the mailing address, the social security number, the driver's license number. You can get how they pay for their cell phone service, whether it's through bank check or through credit card. So there are different statutory bases that get at a lot of different kinds of information. There is nothing that I'm aware of, Congress has not addressed it in any way, shape, or form, that it specifically addresses Stingray-type devices. It is, so the statutes that magistrate judges deal with, there's Electronic Communications Privacy Act, which was enacted in 1986, coincidentally the same year that the FCC first started authorizing the use of cell phones. So that statute is very old and antiquated and doesn't really fully envision some of the implications of cell phones. The Patriot Act amended that statute in some respects in 2001, notably to address emails and the use of emails and sort of pen register-like information for ingoing and outgoing email addresses. And as we're all aware, Congress is not really functioning in a manner that it should be these days. So they're not really equipped to handle a lot of this technology. The technology is developing faster than I think Congress is capable of keeping up with it. And so magistrate judges are essentially looking at what they have, but that's another reason I think the default standard should be the Fourth Amendment. So,
well, I get maybe the question, I didn't get a chance to ask it to the previous speaker, but I guess we have local units of government that are starting to use these devices, and I think it's in Oakland County, so one we're kind of discussing right now has the Hailstorm device. Besides knowing what phone numbers are in the range of that device, what other type of information?
Yeah, Representative, that was covered, and I was going to bring Chris up and spend the last 10 minutes kind of going over maybe oversight policy, and he can touch on that as well. But I think Chris, the first speaker before you got here, talked about that, so we'll make sure that that gets answered.
Okay.
Okay. Chris, did you want to, if you wanted to join, I've just got about 10 or so minutes, and I'd like to kind of get some insights. If you want to answer that question real quick as far as other, again, other data or other information can be extracted, and then also just kind of, if both of you can kind of start talking about suggestions as far as potential oversight, or maybe what, I think you mentioned other countries, something like that. But
so most of what we know about this technology comes from the competitors of the Harris Corporation, who have been far more liberal in publishing their marketing materials. So there are Israeli companies and Chinese companies whose marketing materials are online and proudly advertise the many bells and whistles in their features, in their products. These devices can get the serial numbers. Every cell phone has a unique serial number that allows the government to say, okay, the phone that was here last week is the same phone that's here today. So they can get the serial number of the phone. By looking to see which direction the signals come from, they can locate the device, initially just sort of to this neighborhood or this part of town, and then they can really home in on it to even this bedroom in this house, or this this room or this window in this apartment building. So they get location data. They can get records of incoming and outgoing calls. The devices, many of them that are sold on the international market, can be used to intercept incoming and outgoing calls, incoming and outgoing text messages, data connections. So when you're using the internet on your device, they can be used to jam calls. They can be used to block calls to specific numbers or calls from specific numbers. They can be used to redirect calls. So you call your colleague and they actually redirect the call to the police. And in some cases, we've seen an Israeli surveillance company even advertising the ability to use these devices to deliver viruses, malicious software, to the phones of surveillance targets. So they have a fairly broad range of features. It's my belief that local law enforcement agencies are getting the older technology. They are several generations behind what the NSA has. But, you know, in time, they will get the newer features also.
But we're not aware what the capabilities of the Hailstorm device that Oakland County has right now. So
we do not know which special features are in the Hailstorm.
There are devices out there that could completely intercept complete phone conversations without the warrant of a judge right now in the state of Michigan.
The Hailstorm materials that have been made available, there's really not much about them that's been made public. Right. But the materials that are available online seem to suggest that it's used in concert with a piece of software called Penlink, P-E-N-L-I-N-K. Penlink is a network mapping technology. So you may have heard in the last year about the NSA collecting records of everyone's calls, and the reason the NSA is collecting that information is they want to build what's called a social graph. They want to know who's calling whom and who their colleagues and friends are and who's important in the hierarchy and who's less important. If you're making calls to someone at midnight on a Friday and they're picking up, you're important, and if they don't pick up, you're not that important. So the Penlink software allows for the analysis of call record patterns to figure out who's interesting in those groups. The Penlink software somehow coordinates or can be used with the Hailstorm, but how, we don't know.
Right, that's more what I was looking for. Thank you.
Thank you.
I would love to find out more about the Hailstorm.
So, yeah, for the last 5 or 6 minutes that we have, can both of you kind of give us a little bit of direction as far as what you think should be, the kind of oversight, like you said, Chris, whether or not we should have this debate, whether or not, and they should get authorization to use it from the legislature, from statute, and we should have this debate here, and we will continue this, but also statutorily, and I think Germany, you said, has some oversight?
So let me be clear. While the debate is in its early stages in the United States, this is a technology that has been in use in other countries around the world for several decades, and Germany is probably the most advanced in their legislative oversight of this technology. The German parliament receives a report every year from their law enforcement community revealing how often the technology has been used and the number of cases that it's been used for. I think, if the Germans can have an open debate about the technology, if they can have explicit legal authorization, if they can have statutorily required reports, I don't see why you couldn't have that in the state of Michigan. Again, it's one thing to have a debate about how the technology should be used, the statutes that govern its use, but I think we should all be in agreement that for you all to do your jobs, you should be provided with information. And that doesn't just mean now, this week, when you're having oversight hearings, but I think on an ongoing, regular basis, you should be getting data about how often it's being used and the kinds of cases that it's being used for. I think it's one thing if this is being used, to find missing children or in cases of terrorism, and it's a very, very different thing if it's being used for, drug cases or other types of offenses. What we see in many other states and at the federal level is, these surveillance powers are granted in the name of fighting serious crimes, and then the technologies make their way into police departments, and then they're used for more mundane crimes. And so the more information that you all have, the better equipped you'll be to perform oversight. I think that Professor Owsley's remarks about notice are going to be really useful. Again, even if you think this is an important technology that has a place in the toolkit of law enforcement, I really think that one of the focuses of your attention should be on the privacy of innocent people, not the targets of the investigations, but everyone else whose information is swept up. There is no reason why you should not be told 6 months down the road, by the way, we got some information about your cell phone. Don't worry, you're not a target. We've deleted it, but we just want to let you know that's going on. Law enforcement may not know where to send that postcard. They may only know the phone number, but the phone companies could send the postcard for law enforcement. Law enforcement could send you a text message. I mean, it might be a little bit creepy to get a text message saying, by the way, we were spying on you, but spying's creepy. So I think notice is going to be important, and then I also think that, there need to be guidelines for the kinds of cases these are used for. I really don't think this is an appropriate technology for all crimes. If this is going to be used, it should be used only for the most serious offenses because of its impact on innocent people. You know, our founding fathers, you know, when they were creating the Constitution and the Bill of Rights, they were really concerned about, you know, the British government going door to door with general warrants, and this technology is a general warrant. You know, they are using it to go door to door in a neighborhood to search people's houses. I also think, you know, I think people should trust the phone companies. These are companies that they give money to who provide them with valuable service, and I really don't think the police have any business masquerading as the phone companies. I mean, that I think is something that the phone companies should be pushing back on separately, but I think this is less a question of when they can use it, but I think that these are really powerful devices, and to the extent that they can disrupt the functioning of the phone network, I think that, you know, maybe this is something that shouldn't be used at all. I mean, how many people's telephone calls should be jammed to allow the police to catch one bad guy? I don't know, and that's not a debate that's taken place, but I think you all are going to need to get some answers to those questions, and I think the jamming piece is going to need to be a central component, because I don't think law enforcement right now really knows how many people's telephones are being jammed, but I do think that is something that needs to get some focus. Brian?
Yeah, Brian, and as far as like, we talked a little bit about statutorily allowing unsealing. I don't know if you mandate or allow it or whatever, but just after the fact to kind of know how these things are being used might be helpful. But any other suggestions?
So one, I want to say that I wholeheartedly agree with Chris on the ability for the legislature to get this type of information through some kind of report from law enforcement or courts. One thing I would say is, and we referenced this earlier, the information is only as good as the provider, and so as a magistrate judge, I had obligations to provide comparable type of information. In talking with the folks at the administrative office of the courts, they would praise the Southern District of Texas or my division on how great we were at providing information, and note that no one else in the country must be having these types of electronic surveillance requests, because we weren't getting necessarily that many reports. So if you're relying on judges to provide the information, you have to make sure that judges are actually providing the information. And that doesn't necessarily always happen. In terms of one of the other things that I'm concerned about is transparency. So all these applications that we're dealing with, whether they're the Stingray type devices, which at least in my experience, aren't happening every day, but you have more commonplace search warrants and pen register requests and 2703D order requests at the federal level. And so that stuff happens on a regular basis, and that stuff gets sealed. And it gets sealed in perpetuity, and there's, I think, some disincentives for judges to unseal it. I tried to unseal a number of these things before I left the bench. The government, which was the agent requesting, the United States Attorney's Office was requesting that it be sealed, did not oppose unsealing it. Ultimately, another judge decided that it was going to remain sealed, and it's still sealed today. So the problem with that is it's only by at least being able to look at maybe what was going on 5 years ago or 3 years ago, as these criminal investigations are over or concluded or too old, that you get a sense of maybe how technology is being used. You'll get a sense of whether or not Stingray devices are being used on a wide scale in a specific area, or if they're seldom used. But without that sort of that transparency, you're not going to be able to sort of have people like me or other academics who will go in and crunch the numbers and analyze the applications. So.
If I can just add one more
We got
thing,
like
just for
2 minutes, 1 minute.
One second.
Yep.
To the extent that you all eventually hear from law enforcement, they will tell you, don't worry, we always get court orders. Just remember that not all court orders equal probable cause warrants. And so if this technology is going to be used, I think a warrant standard based on probable cause is the right standard, is the minimum standard to be considering. Don't let them tell you, don't worry, we get a court order, and then you say, okay, well, that's fine, everything is cool. They are likely getting this information with less than a probable cause standard, and to the extent they are getting warrants, I doubt they are telling judges about the number of innocent people whose information is being obtained. I think if magistrate judges knew the true scope of this technology, I think they would be very reluctant to sign on the dotted line.
All right, well, thank you. And also, I think we have a lien system where we have felony charges, and I think the law enforcement from time to time, if they're looking up their ex-girlfriend's information, they're subject to felony. I think those kind of penalties should probably be there for unauthorized use as well. So I appreciate you both coming in. It's been extremely revealing, and I think that it's started a good conversation, hopefully nationally, but especially here in Michigan, and that we will follow up with you and hope to gain your or utilize your expertise in the future as well. So thank you very much.
Thank you for having us.
With that, we
Thank
are
you.
adjourned.